what was the end game? Because, and by that I mean, because there are a lot of people who are involved. And what the court is seeing is some of this. I think it's listed.
When a judge highlights elderly victims, the courtroom shifts. These aren't just numbers on a checkbook. These are people who trusted a handshake and lost their peace of mind. That's what makes this case sting.
No criminal past, leaving Judge Boyd in a pickle, but she does what she could with what she has, and the most disgusting part of this case is the details of a shady past, and that he's done this to someone before, and that his victims could have been your grandma that lost a Social Security check because this jerk in a polo said he needed to quote-unquote cover bills. Crimes of moral turpitude make me sick because the victims are usually so innocent, but tell me how you feel about this by
Moral turpitude, a fancy term for actions so unethical they stain your reputation for life. It's not just a crime, it's a character test, and this defendant failed it miserably.
Are you all ready?
We're on the list, Judge.
Okay.
Also, there are a couple. We've submitted a memo in that case as well. So when it comes to us, there is a sentencing memo.
All right. Can I see the sentencing memo? I don't know. What's your client's name? Lunsford. Is that next? And defense, are you all going to have witnesses? Okay. And state, are you going to have witnesses? All right, so if parties can approach on this case, please. So has the restitution been paid in full? All right. And before we go on the record, any objection to the court reviewing the PSI?
No, ma'am. No objection. The only qualification is there is a letter written by a ex-mother-in-law that really has nothing to do with the merits of the case.
Is that Matthews?
Yes. Yes, ma'am.
Okay. So you'll object to the court reading that?
I don't object to you reading it. I just simply ask that it be taken into and put in the context it deserves. As I told Mr. Locke, without diminishing the seriousness of today at all, if I'm ever sentenced and any ex-mother-in-law I have has a vote, I'm going to the Polunsky unit. But other than that.
Really?
Yes, ma'am.
Oh.
2 out of 3 anyway.
Okay. 2 out of 3. Is there a common denominator?
Yes, ma'am. Yes, ma'am.
All right, just y'all can remain here. Just give me 5 minutes. Righty. We're going to go on the record. Court is calling 2025 CR 001023, State versus Mark Davis Lunsford. But I have parties announced for the record.
South State.
Dan Togdell and Sam Locke from Mr. Lunsford, Your Honor.
And are you Mr. Lunsford?
Yes, Your Honor.
You entered a plea in this case. As a part of your plea bargain agreement, you want to pay the restitution up front. The restitution amount was $297,000, well, approximately $297,000. Has that been paid up front?
Yes, Your Honor.
According to your plea bargain agreement, the state is opposed to your application for deferred adjudication. The state is recommending community supervision. What I can tell parties, since he has paid the restitution upfront, the court is going to follow your agreement in the granting of community supervision. So the only thing that needs to be addressed here is the application for deferred adjudication. And state, you are opposed?
Yes, Your Honor.
All right, and if you could explain?
Yes, Your Honor. There are 55 counts in this indictment. This defendant pled to one of them. In its essence, it's just a theft case. It's a theft case. It's a theft that went on for many years. What we allege is from at least 2010 to 2019. Mr. Lunsford was an insurance agent. He stole money from his clients. And went on for a long time. It went on repeatedly. And it went on even after the Department of Insurance revoked his license practice and to settle and collect payments and that sort of thing. I know the court hears a lot of theft cases, and it's certainly a miserable experience to be victims of that. But I think it's even worse whenever it involves a breach of trust that results in victims losing a sense of security. We all rely on certain people to handle our money, and we trust them to do that, whether they be financial advisors, bankers, insurance agents, etc., CPAs. But I think we have that luxury of trusting them to.
A little courtroom humor there. But let's not forget, behind the laughs lies a serious fraud case. Even judges appreciate levity. But when sentencing starts, that smile disappears fast.
For restitution of these victims as what we can collect. And I think that the reason that we are opposed to the deferred adjudication is so that the punishment for Mr. Lunsford will have a permanent effect and will have the effect of warning others in the future by having it on his record. The state did also seek a jail sanction as part of the plea bargain, so we recommended it in the plea bargain because of the scope and gravity of the fraud that was perpetrated by Mr. Lunsford. While it's laudable that he made this upfront restitution, and that was a primary goal of the state, so that these victims did not have to be delayed justice any longer in this case. But the reality is that payment could have been made at any point while this case was pending. It was pending for a long time to be indicted, and Mr. Lunsford is aware of the investigation. So for that reason, for justice for these victims, that's why we are asking the things that we are asking for today.
All right.
Good morning.
Thanks.
Mr. Lunsford is here today with his wife, Claire, with his first cousin, George Craig, and Miss Landers and Miss Salinas, who are neighbors of Mr. Craig. He's 49 years old, save and except a fight that he got into when he was 17 years old that was resulted in his successfully completing a misdemeanor deferred. This is his first interface with law enforcement. He has, as the state pointed out, made right at $300,000 in restitution. He is happily married. He has 2 adult children by a prior marriage, 2 stepchildren by this marriage. The difference in deferred adjudication is a difference with a distinction in this case for a number of reasons. One, it's a first-degree felony. If he should violate the terms and conditions, obviously he opens himself up to the full range. Second, he's a certified crane operator. A straight probation, which is obviously a conviction, will bar him from doing work at a federally supervised facility, which basically in Houston is about half his work, so it's going to impede significantly on his work. But we would ask that the court consider the deferred adjudication, given his full restitution, given the community support he has, and given his ability to continue to be a successful employee.
All right. So what I read in the PSI, there's a mention by someone who's not his ex-mother-in-law. Someone else said that he had done this before with State Farm.
I don't believe that's in the evidence that was submitted, State's Exhibit 1, that person may have had knowledge of that information. I generally have knowledge of that, but not specific information enough to give the court about prior case and
well, I'm just addressing it because it's included in the packet that I received with the PSI. So does Anyone want to address that?
Yes, Judge, just briefly, there was discussion.
This is where the real pain lives. Not in the stolen cash, but in the broken trust. When an insurance agent turns predator, every future handshake feels like a gamble.
For the first time, I would submit to the court that the state has had this case for a while. It's been ongoing litigation. If there were other charges to be made, they would have brought them. The plea bargain before the court was with the work of Mr. Stout on behalf of the state and Texas Department of Insurance and counsel for Mr. Lunsford. And we'd ask that the court rule on what's in front of it that's been charged. It's just a vague allegation without a signature, and it's very difficult to address, Your Honor.
All right, so are both parties asking the court to disregard that?
Yes, ma'am.
Yes, sir.
All right, then the court will disregard that.
One brief reply in response to Mr. Stout, Your Honor. He indicated that it took Mr. Lunsford a minute to effectuate restitution. We made it clear from day one when he was charged, I think back in February, that our intent was to pay this. It took Mr. Stout a while to get the restitution effectuated or together, which we understand. But we've always represented we wanted to make restitution.
All right, so here's my question, and I'm just trying to weigh on whether or not to grant his deferred or not. What was the end game? Because, and by that I mean, because there are a lot of people who are involved. And what the court is seeing is some of this, I think it's listed as elderly persons who had, I guess, their premiums or whatever that they thought they were paying that were taken. I mean, what, did he not think anyone would ever report this? Did he not think that at some point somebody was going to need to use their insurance and then their insurance is canceled and they don't know about it? What?
Judge, I can't crawl back in his mind back at the time. I think this was another example of, for lack of a better description, thinking that he could muscle his way through it and eventually get the insurance that these people wanted, and just never did.
All right. Is there anything you wish to say?
Just like to.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, but nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mark.
All right, what would you like to say?
I submitted a written statement that just to kind of.
The judge just made a critical move, refusing to consider unverified allegations. In a world of speculation, this is a reminder. Courts run on proof, not gossip.
Take full responsibility. It left a mess in my wake through decisions.
But I mean, see, I love to have as much information as I can have. I'm trying to figure out what were you thinking when you were doing this, because it's more than one person. It's not, oh, I did this one time. Did you need money? I mean, what was the point?
This was failing. I was trying to cover bills, and it comes to the ball on me. I knew it was wrong at the time. I felt there was my course of action at that time, and that I would correct it, I would fix it, and it just got out of. Doesn't excuse my actions. It was wrong. They're wrong. 2019, I walked away from all that. Been employed by the same employer ever since.
All right. Is there anything else?
Nothing can say.
All right, I'm going to give you a choice because it appears that you don't have any criminal history other than this. Is that correct?
That's right there.
All right. And I've been asked to disregard certain things, and if there's no information before me that that the defense had a chance to question and put to the test of its truthfulness, then I'm not going to consider it. So these are your choices. This is your only choice. You have no other choice. 1, I'll grant your deferred for 10 years, but you're going to be taken into custody today, and it's going to be 180 days. 2, I can find you guilty, and I'm not going to give you any time as a condition of probation. Those are your only two.
Here comes the apology. But let's be real. Can remorse erase years of betrayal? Tell me what you think. Is saying sorry enough when you've drained people's savings?
10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no employment handling any financial transactions. There's to be proof of employment within 45 days. No employment as a home healthcare provider or with minors. There's to be 200 hours of community service restitution. Probation, the felony anti-theft course, is that similar to CAT's 1 and 2 theft course, or is that something different? All right, so which do you think is most appropriate?
CAT 1 and 2, in my opinion.
All right, CAT's 1 and 2 theft course. And does that encompass the MRT?
No, Judge.
All right, the MRT. With regards to Houston, are you asking that it be transferred to Houston?
Yes, ma'am.
And I'm so sorry, is that Travis or Harris?
It's Harris.
Okay. Transfer to Harris County. Field visits, Ms. Abram, is if they do them one time per month for 6 months. And there's to be no contact with the complainants.
Judge, one of the complainants is Mr. Lunsford's father. He did not ask for restitution, and he still enjoys a good relationship with his father. So I would ask that not be enforced.
We agree with that.
All right, there's to be no contact with the complainants. The only exception is the defendant's father. Probation, is there anything else?
No employment.
Handling any type of financial transactions.
Nothing else, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
Did you assess a fine? We've our plea bargain.
All right, there's a $10,000 fine. The court will probate 5,000 of that. No one usually know where the fine goes. It ends up disappearing and we can never track it. That's not me, that's the government who cannot track it. All right, there's a $10,000 fine. 5,000 of that will be probated. If you successfully complete everything, you only have to pay the $5,000. If you do not, you're looking at the full $10,000. Do you understand?
Yes, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing, since you accepted the guilty, even if you would not have accepted the guilty, this is a crime of moral turpitude. Anything that requires a license, you need to let them know that you have this. Do you understand?
Yes, Your Honor.
All right. Is there anything else from either side?
Just one minor thing. When we did the plea, there was a page in the SIPs that had a secured area with a postage stamp. And I have the updated or clean version of it.
All right. Thank you. And you're offering this?
Yeah, I'll up and see it's I'll be without the structure.
We talked about it before, Your Honor.
All right. Then the court will accept an amendment to the stipulations, and it appears to be a document from the Texas Department of Insurance. And I'm sorry, one more thing. He has given up his license, correct?
It's been revoked, Your Honor.
All right. Is there any request that he's not to obtain any insurance license?
It's not part of our plea bargain, but obviously the felony conviction is something that would
We don't have an objection to the court entering that.
Yes, I'm going to put that in because you never know what will happen. So, defendant is not allowed a license in insurance, any type of insurance. All right, once you go over the paperwork with probation will be excused, and this court communication is key when you're on probation. If there's an issue, let probation know about it.
This is the moment of truth. Two paths. One keeps him out of jail, but brands him forever. The other sends him behind bars. It's not freedom. It's a sentence either way.
My mom says that other than being at home, the most time you spend is at work, and you should try to make it as beautiful as possible. So she would always tell me all the time, she said, if you cannot spend $20, because that's what it costs, if you cannot spend $20 on yourself, then what are you working for?
Good for you.
But so
Good for her.
that's me. This is for Bosses Day. So, and my staff is so awesome.
I just got death threats on Boss's Day too, but that's.
Oh, that's messed up. Oh, and I forgot. So, and also my students will send me flowers. But it does, for the record, it doesn't improve their grades. Their grade is their grade.
Thank you.
Thank you.